Good afternoon, seniors. Good afternoon, colleagues. Good afternoon, learned friends. If you can hear me, kindly say hi in the chat box or give me a thumbs up. Okay, okay, okay. So you are all welcome to the fourth session of our webinar series designed to equip lawyers transition from classroom into practice. Having been in practice for 4 years and having experienced firsthand the challenges many young lawyers face, these series were designed to equip lawyers for a seamless transitions from the foundation we receive in law school and what actually transpire in practice. I can say we have 70 participants already, so I'll proceed to introduce our speaker, after which he will give a general overview of the topic, and then there will be an interactive session where we will ask questions and our speaker will assist us with the answers. If you have any question, you can leave it in the chat box, and when it's time for questions and answers, I'll read them. Our speaker is not a stranger to law students. He's been teaching for over 2 decades now. He served as the Dean of the Faculty of Law of Kwame Nkrumah University of Science and Technology. And he's also served as a consultant at Owusu-Dapaa Law and Associates in Kumasi. Beyond his contribution to legal education, our speaker has had an outstanding career in academia, public service, and also in legal practice. I personally benefited from his lessons. During he used to organize classes to prepare law students to take the entrance exams, and I personally benefited from that. So I can confidently say that most lawyers or law students have passed through his mentorship, his guidance, and his teachings. Today, he is a justice of the Court of Appeal, and I'm privileged to introduce our speaker, Justice Dr. Ernest Owusu-Dapaa. My Lord, thank you for making time for this session. I know how busy you are, so we are grateful for joining us this afternoon. I will now humbly invite you to give us a general overview of the topic, after which we will have a question and answer session. Thank you, my Lord. My Lord, your audience, our justice. Thank you.
Thank you very much, Nana Yaa, and good afternoon to you and to all lawyers and other members in the audience. Thank you for the initiative. I personally enjoy learning and sharing knowledge and experience and learning from others too. So those of you who follow the Ghana Law TV, which a YouTube channel I started around the COVID time when we were trying to help students get ready for the law school entrance examination. From time to time, as I'm able to get some time, I try to do some small CLE, continuous legal education, because I am of the view that Learning does not end with graduation from the law school or from various academic degrees as well. It is a lifelong thing, and I am a lifelong student of the law, and I want to believe that every serious person with the law will agree with that view that you never finish learning the law, and that is why I'm happy that you are doing this initiative. Yeah, so to start with, we have to remember that all that we learned in the law school was to be taught the law, the substantive law, and to extent the law of procedure, procedural law. However, uh, we have to see the law school as creating the floor. The floor, that is like the minimum. So the law school, the law faculty, all that we have been taught and all that we have learned gives you like the minimum to start to become a good and a serious lawyer. So that is the floor, the starting point. It's never the ceiling. So it doesn't matter whether you had 100 over 100 in a particular substantive law or particular procedural law. It is still just the starting point, is the floor. Now, the ceiling is what happens in practice. So that is very important. So the law school give us, if you like, the map. A map is supposed to direct you where you are going, but the map is never the destination. It's not the territory. The courtroom is the territory, and the territory is certainly different from the map. The map is supposed to guide you, but where you are is the rare thing. So let us keep that in mind. And let's face it, you've written a lot of examinations. The doctrines or the knowledge, substantive law, everything, even procedural, you know it, you scored high marks. But you agree with that, with me, that you were never examined in the law school concerning how you can lose a case with the credibility intact, or how to read a judge's silence when a judge is quiet in the courtroom, is communicating, but you are not taught that in the law school. And you have to actually pick some of these things in practice. And you will notice that much as the textbooks, instruction will be given are necessary, they are never decisive in terms of success, in terms of making impact as a practitioner. Because we notice that ultimately cases turn on preparation, posture, candor, how honest, how frank you are, and then your professional judgments and also restraint. These things I've talked about: preparation, posture, candor, professional judgment, and restraint. These are never examined in the law school. So let us keep that in mind. They're never examined in the law school, and it's something that you have to pick up as you come into practice. So preparation is not a vetting. Preparation is the precondition for everything else. You have to prepare, prepare, prepare. For example, I've been a lawyer and I was called in 2003. That is about 23 years. I did in October. I've been a judge for 4 years. I've been university done and stuff. But I must always prepare whatever I am going to do, because preparation is everything. And that is true for a a lawyer or legal practitioner as well. So preparation, preparation, preparation is necessary for everything else. as whether you are going to be confident in court, you are going to be confident in the case you are doing. You'll be able to show the requisite, courtesy, decorum, and so it all depends upon your preparation. So you have to know your brief better than anyone in the courtroom. As far as the case is concerned, your case, for which reason you're in the court, you must have absolute and perfect knowledge of it in terms of pleadings, whatever witness statements are on the file, exhibits, dates. If I say dates, you must have a good record of chronology. When did what happen as far as the case is concerned? When did the court sit? What happened on that day? When was the court supposed to have sat, but the court didn't sit? And then you went to court and you're giving date off record. You must have a good chronological account of all these happens. And if you are a lawyer and you're in the courtroom, you have to hunt for a document. You are struggling to locate a document. You've already lost confidence of the judge. You've lost confidence of the bench because it's your case. So if it's your case and then the court, for example, shows okay, so counsel, the amended statement of claim, when was it exactly filed? You cannot provide that information unless you see that process and you look at the court stamping date on it. So let's suppose that question has been asked and you are fidgeting, going back and forth your file, trying to locate it. A minute, is gone, you still not find it, you are still struggling. Psychologically, the judge sitting there will not be confident in your seriousness and your preparation as a lawyer. So preparation is very important. If you have prepared very well and you have properly arranged, your file and you know where everything is, you will not struggle actually to locate the requisite process, which the bench or the judge has actually requested for. So preparation. If you take preparation serious, you have brevity. You not have long talk or prolixity in your courtroom speeches because you are prepared. You use just what is necessary to communicate your position or your answer to the bench. But without preparation, you cannot have brevity. Again, you must anticipate questions before they are asked. And that can only be possible where you have prepared. If you have studied your brief well, you know the strongest point of your case. You know the weakest point of your case. If it is a motion you are going to do, you know that this motion, this is the strongest point, and then this is the weakest point. And because you are prepared, you'll be able to anticipate questions which the bench may ask, or competing viewpoint which your opponent is going to bring up. So nothing will be a surprise to you. But if you have not prepared, things will surprise you. For example, it is sad if a lawyer, you're going to, for example, deal with a motion and you go to the courtroom, your opponent cites authority, and that authority is not familiar to you in any way. And it's like we're hearing it for the first time. And then you have to now struggle and probably go to your phone and try and find out. Now that raises a question mark about your preparation, because from our training as lawyers, we all know where to find the law, how to locate the law and read the law. So if you had prepared adequately, you have also played the devil's advocate. In other words, you would have endeavored to put yourself in the shoes of your opponent and try to find out, okay, if I am coming from the perspective of my opponent, what are the arguments that I'm going to deploy? And what authorities am I going to anchor my arguments upon? You have been able to, identify this. And for that matter, you go and read around them. And when you go to the courtroom and your opponents start even citing them, it's not new to you because you know it. And you have also thought about it, how to try and minimize the impact of those authority. Either you are going to distinguish that authority from the facts before the court and so on. So you start and then you let the judge know, yes, on the surface, this authority is very much close to the case of the plaintiff applicant or the plaintiff respondent, as the case may be. However, my lord, upon a closer examination, it will be noticed that whereas in this particular authority, so happened, we notice in this particular case that there is a very important a factor here or fact which changes everything. My lord, I refer you to paragraph 8 of even the applicants who are affidavit in support, and also paragraph 14 of the affidavit in opposition. Then you try to use the information to build the argument that yes, there seems to be an authority which is against your case. However, if you subject that authority to closer scrutiny or examination, an important distinguishing can be done. And you've done that. Now, you couldn't have done this without preparation. And that is why preparation is what is important. So preparation is very important. And the court can always tell who has read his brief well and who has not read his brief well. When we talk about confidence, it's not about the dressing, the big suit, the expensive suit, the makeup, the hair and things like that, the bag, and which give confidence. No. Of course, a lawyer must be well and decently dressed. There's no doubt about that. But your apparel or your physical presence is not equal to confidence. Confidence comes from preparation. So confidence is not in the personality. It is a byproduct of the work done the night before. You're going to go to court tomorrow. You have to do some work in the evening or the night before the scheduled date so that you are quite fresh regarding the file. And when you go to court, you know what you are going to do. And every case should be treated as a serious case. Don't allow the value of the relief of the plaintiff or the counterclaim to determine how serious the case is. And say that, oh, this one, we have about $10 million at stake. So this is a very important case. But this case, if I look at it, even the whole value is just about 100,000 or 50,000 Ghana cedis. So I'm going to do it anyhow. No. If you look at the law report, you will notice that some of the cases which have become a landmark in terms of their presidential value, as far as the economic, weight is concerned, it was nothing, really significant. So it's not so much about the money value of the case. Every case is a case, so long as it's a dispute and it has come to court, and you are a professional and it has been given to you to represent someone, you have to prepare and bring all seriousness to bear. Another point I would like to touch on is credibility. Credibility is your currency. What do I mean by that? If the court is going to respect you, if the court is going to have confidence in you, you must be credible. You must be credible. And if you don't take this serious, your standing and everything can be destroyed just by one slip before the court. You can never recover it. Now, with respect to credibility, from your legal advocacy, and you have been taught that your duty to the court ranks above your duty to the client. It is true you're representing your client. That is true. But you are first and foremost a lawyer. And a lawyer is someone who is using his knowledge and skill with respect to the law to advance a particular interest. So don't just seek to advance the interest without the knowledge of the law and the skill. And that is why your duty to the court becomes important. If there's a bad point, you have to concede it. There's nothing wrong with concede. For example, you filed I'm going to give you an example. Sometimes I sit as an additional high court judge. There's one particular case, for example, I'm not mentioning it, but I'll just give the example. There's one particular case where a lawyer says that the other party has not filed defense, and for that matter, the lawyer has filed a motion for the case to be set down for trial. And you look at it closely and you notice that where there's a default of defense, and even if you cannot get judgments in default of defense and so on, and you need to, the rule says that you have to, the case should continue as if everything is normal. You don't just ask the court to set the case down for trial. So let's suppose that you filed a motion like that, and then you go to court. But let's say that before you went to court, you did some reading, you realize that the motion that you filed is a bad motion. If credibility is important to you, and where you have the ability and humility to concede bad point, when you go to court, the first thing you do is to apply to the court to withdraw the application. Don't even allow the application to be considered, because you've seen that there's something wrong with what you've done. So you apply to have the application withdrawn, and there's nothing wrong with that. Sometimes you have an argument which is really untenable, and you believe it, but then the argument is just untenable. You have to concede it. And from your preparation, you have seen that this particular argument is not untenable. It's not tenable. Let me go and try it. Then you go, and then the bench, for example, engage you, and then you see that how you're being engaged by the bench is consistent with the problems that you even identify when you're preparing. You will just right away consider and move on to another thing. So that is very important. If you are a lawyer and you want to win the trust of the court, you need to take credibility serious. You must exercise a candor. That is very important. That is very important. Again, procedure is very important. So if you are going to make it, as a practitioner, procedure is very important, and you notice that a lot of cases are won or lost on the battlefield of procedure. Sometimes the case is good, but then if the proper procedure is not used, you are going to lose. And don't be deceived by Order 81. as far to Gate and all later authorities and say that yes, or the 81 is insurance, so you are not going to take procedure serious. No. Mind you, even where or the 81, particularly where the non-compliance is not a mere regular, it's a mere regularity, it's not a nullity. So the court is going to condone that irregularity. It may be subject to cost, and assuming no cost is being inflated on you every now and again, you are doing your client the service, and your client may lose confidence in you. So you have to pay attention to procedure. And with respect to procedure, there's something I've observed which I would like to share with you. If you are going to be a trial lawyer, pleadings are very important. Pleadings are very important. And you can do good pleadings where you have listened to your client properly, understood your client story, and you have done proper interrogation of the story on your own, and based upon your knowledge of the law, you know the course of action of the particular defense, and you've read around it. So please don't just rush to do pleadings without doing a bit of background reading, because you are setting the case up at the pleading stage. You are setting the case up at the pleading stage. And as a lawyer, when you are setting up your case, you must always know what particular law am I basing my case on? What principle, what doctrine am I basing my case on? Read around it and then look at the story you have. And that will enable you to set out the pleadings properly. Don't be very casual, about pleadings. Pleadings are very important. If you do your pleadings very well, you will notice that when it comes to writing your witness statements, helping your witness to put the witness statements together, you do very good, very good witness statements. And because you have applied your mind to the pleadings and good witness statements, when it comes to trial and you're going to do cross-examination of your opponents, you'll be able to do meaningful and incisive cross-examination, not just asking questions for asking sake, because you've applied yourself to the case. So if you want to be able to sharpen the skill, the competency of doing good cross-examination, take pleading serious. Take pleading serious. If you take your pleading serious, I am sure you are going to become a very good lawyer, because you know how to do background work before you sit down to write your statement of claim or your statement of defense or reply, counterclaim, and so on. And because you have done that, you have a proper understanding of the case in terms of the relevant legal principles or doctrines, and also the essential things which the law requires, for example, should be established for those type of cases or the particular type of defense you are thinking of. You're quite clear in your mind. And for that matter, if you get your opponent's pleadings and the witness statements and so on, you can easily begin to flag areas which need to be probed during cross-examination. So there's no magic. Don't expect that you'll be a good cross-examiner without paying attention to your pleadings. Another thing maybe I'll touch on is that when you are in court and the judge, for example, should ask you a question, please deal with the with the question as asked. What the bench is asking you is what the court is interested in knowing, not what you want to tell the court. So let's understand that. So don't ignore questions from the bench. Don't ignore questions from the bench. And also when you are, in the courtroom on your feet, there's that temptation to want to impress those in the gallery. That is like the other people in the court users, your client. No, the courtroom is not a performance. It's not theatrics. Anybody who said that courtroom advocacy is a performance or theatrics, the person is not like a very serious lawyer. Because it's not you. At the end of the day, it's not a popularity contest, right? From the audience in the court, which is going to decide the case. No. You are addressing the court. And when we say the court is the judge. You're addressing the judge. The judge is the one who needs to understand the case, who needs to understand what you are saying, so that when he or she sits down to compose his thoughts regarding rulings or judgment, he will be assisted by what you did. So when you are speaking in the courtroom, that should be your focus. What I am saying, am I helping the court to understand the case from the point of view of my client interests based upon the law that I know? That should always be your guiding principle. So don't just be talking for talking's sake. Don't be saying victim just to make yourself happy that, my lawyer has spoken. No, that is not what is important. When the judges are sitting at the top, they are not moved at all by the drama that some lawyers do. No, we are interested in the substance. So don't raise your voice. Have a cool composure. Good advocacy comes from cool composure, not just raising your voice or just appearing very disrespectful to the bench. Mind you, the bench or the court is a human being like you. And just as situations can impact on our psychology at a particular point in time, in my view, the same thing applies to the bench, particularly so where there is what we call an exercise of discretion. When we say exercise of discretion, that is to say that the court has a lot of latitude or room within certain parameters of the law, and it can go left or right so long as the evidence before it can justify one way or the other. So you do not want the court to be quote unquote unfriendly towards you, as it were, when it comes to those movements. And that is why you need to be respectful. You need to have a calm composure. And having a respectful and calm composure is not only to the court, but to your colleague lawyers on the other side. Because if you attack your colleague lawyer on the other side, you think that you are just disrespecting your opponent, but it's the court that you are disrespecting. Why do I say that? When a lawyer is on his feet, despite the fact that he's representing his client, he's an officer of the court. An officer of the court, you are, if you like, under the control of the judge. And the judge is the boss of the courtroom at that moment. And all officers of the court are under supervision. So if your opponent, for example, is being insulted by you or being disrespected, it's not just the opponent that is disrespecting, you're also disrespecting the court. So let us keep that in mind. So we have to, you don't need to actually be very belligerent, in the courtroom to win your case. No. And it is often sad when the bench, for example, when it comes to costs, the court will say that, okay, uh, counsel, agree among yourself. And then when you get to that stage, you notice that uh, lawyers, they are not able and they will just get up. Why? You know the law on costs, no order 74 and so on, where a cost has actually been incurred, it will be actually be awarded anyway. But all that the court is doing is to give the two of you to reach an agreement regarding the quantum. So how can you say that we are not able to agree? And then we just leave it to the courts. And all this happens because of anger towards your colleague lawyer. So let's look at that. Nana Yaa, I think I will yield for you to bring up issues so that I speak to the issues that you are bringing up rather than just me talking to you without any particular reference. Yes.
Okay, thank you so much, my Lord. This has been very insightful, and we shall remember that preparation is key, credibility, and we should take our procedure also seriously. My Lord, you mentioned that we shouldn't ignore questions at the bar, at the bench, sorry. But my Lord, at some point, every advocate faces difficult questions at the bench. And I don't think it's deliberate that we ignore the questions, but at some point we encounter unexpected questions despite our preparations. So what advice would you give to lawyers when we encounter such situations?
All right. Thank you, Nana. Yes. So we all appreciate that nobody who is very sincere will say that he or she is a walking encyclopedia of anything. No, we know that. However, as far as the case you are presenting on a particular day is concerned, you are supposed to have a significant mastery over it in terms of the law and the facts. And going back to my work preparation, if you have prepared well, in terms of the law, there's no relevant law or no relevant major authority which will have escaped your preparation. In terms of the facts surrounding the case, if you have taken your time to review the file well, there is no facts which will have escaped you. Now, there are some, I remember, I know some lawyers, especially juniors, they'll say that, not until my senior just gave the brief to me that I should go and take a date, or I should just go to court this day. So I'm not familiar with the file. Please, as junior lawyers, take this advice. When you are in the chambers, you as a junior, be proactive. Go to your senior and say that, senior, I want to get all the files of cases we have next week. I just want to read them and then make notes and then put on the file. So you don't only wait when you are going to court. All the time, when you're in the office, be working on the file. And if you be working on the file, you will notice that anytime you're working on the file, you make notes, you review everything is there. So if you are asked to go and hold brief or you are asked to go and conduct a case, you are very familiar with the brief. So this attitude of somebody who go to court and say that my senior just asked me to come, so I need to go and consult my senior. Judges hate that. Once you are a lawyer, you have finished your privilege, you'll be licensed, you're a lawyer. It doesn't matter the case, you are a lawyer. When you are on your feet, you, the person on your feet, is a person who is known by the court. Now, in terms of you not knowing the question, if, for example, the question the court asks relates to maybe an authority and you honestly do not know it or something, there's nothing wrong for you to say that, respectfully, my lord, from my diligent preparation before coming, I think I seem to have lost track of this particular authority, but it's something that I can easily finish at the short adjournment if my lord is graciously so disposed. If you talk this way, no judge would still, be hard on you and just let you feel embarrassed. You have shown humility, you have shown candor or frankness or sincerity. Yes, you've prepared, but then this particular case, this authority, is not something that you can finish it immediately. But if the court is disposed graciously to allow a short adjournment, you're very happy to finish it. I mean, that is fine. Yes.
Okay, thank you very much. But if you have any question, you can raise up your hand and I'll unmute you so you ask. Alternatively, you can type it in the chat box and I'll read it out. The floor is now open for questions. Okay, John, I see your hand. John, you can talk now.
Thank you very much, Nana. Yeah. And my Lord, as usual, we are very grateful for your insight. You've been with us since day one from LLB days, and even at the bench, you see create time to help us become best, good lawyers, and we really appreciate the work that you've been doing for us. My question has to do with, at times, maybe not most times, but few times, what happens when a lawyer observes that the bench is wrong? And how do we go around this so that we don't come up like disrespectful and yet be able to point out to the bench that the position as we know it may be different from what is coming from the bench? Thank you, my Lord.
Yeah, thank you, John. Thank you very much. That is a really important issue you brought up. Yeah, so as you rightly said, the bench, although we say that the law is in the bosom of the judge, but that does not mean that in reality, the judge is a working encyclopedia of substantive and procedural law. Judges too can make a mistake. However, of course, if judges don't make a mistake, there will be nothing like having the court for appeal and having another appeal to the Supreme Court, or having the High Court being appellate court over the district courts, as it were. So, error or human fallibility is very much part of everything, including the work of judges. However, it is not appropriate for a lawyer to just on his face look into the face of a judge or magistrate and say that, my lord, the greatest respect. And then the position that you have stated, you are quite wrong about that. And no, you have to add what we call the wisdom and maturity to how you go about it. If, for example, let me give you an example that let's say that someone has brought application for summary judgment, and the judge is saying that, oh, counsel, the defendant has not even filed a statement of defense, and I cannot deal with it. So how can you say that the defendant does not have a reasonable cause of defense or reasonable defense? So certainly, if you look at Order 14, you know that application for summary judgment may be brought after entry of appearance. But what the judge is saying seems to be saying a position which is contrary to what the rule says. It's permissible for you to bring application for summary judgment after the opponent has entered on appearance, so long as you know that your opponent does not have any reasonable and no probable defense to your case, and you can get the supporting documentary proof as part of your affidavit. You can do that. But what the judge, for example, said is not correct. But you don't just tell the judge that my lord or my lady, you are wrong. All that you could say is that, yeah, my lord, I mean, the position that you have stated is a plausible view, but respectfully, my lord, if you permit, maybe may I quote Order 14 rules also and so and so. And then the judge will say that, okay, proceed. Then you take your time and you start reading it. Now, as you are reading it, assuming the judge is one who has not read the rules, and for that matter, made that erroneous statement, he or she is a rational being. He's a judge, a very mature person at that level. So as he or she is listening to you quoting, he or she will know how to correct himself or herself. Yes, he or she will know how to correct himself or herself. It's just like a teacher who has said something in the classroom and it is wrong. And then the student has been able to maybe point to something and then becomes aware to correct himself, because no one has a perfect knowledge of the law, be it procedure or substantive law. But it all depends upon the approach, how you go about it. How you go about it. Yeah, so that is what I would say, John. Thank you.
Okay, thank you, my lord. There is Omar. Omar, please unmute. You can talk now.
Hello, good afternoon.
Good afternoon.
My Lord, we are grateful for this time you've given us. I'm Omar from Tamale UDS School, Faculty of Law. In fact, I want to find out in the courtroom if a judge makes comments in the course of trial which appears to be prejudiced to the case of a particular party. How can that counsel go about such situation? That's one. And secondly, similar question, but in case of a jury trial, and the judge maybe makes comments that might incite the jury to take a particular position in respect of the case. In such situation, too, how can the defense counsel go about it? Thank you for this opportunity.
Right, thank you, Omar. Yeah, so the first one, where a judge makes a prejudicial statement, a judge makes a statement which actually shows that the judge, for example, is preferring one particular case to a party's case to the opponent's case. What can we do? Good. Now, it will depend upon the particular circumstances. Some of those statements may seriously be prejudicial, that the judge may have to recuse himself. Otherwise, if you take up the matter later on, you may probably win. But as I said, It's not every statement that you interpret as the judge appearing to be endorsing your opponent's case over that of yours. Over that matter, the judge must recuse himself and refer the matter to Chief Justice for the Chief Justice to assign it to another judge. No. So it will depend upon the weight and the circumstances of whatever statement that you are referring to. And again, when it comes to jury trial in criminal cases, we have what we call the summing up. It is the judge's duty to sum up the evidence and also explain the law in relation to whatever offense the accused person is being prosecuted for to the jury. Mind you, the jury, they are not lawyers, but they are going to make findings of facts. But the findings of facts must also be informed by the correct position of the law. So the judge will have to explain. So a judge must always give a very unbiased and position. If this and this and this is what happened, then you have to bring a verdict that the accused person didn't do this, or this and this and this and this and what happened, that the accused person did this or that. So it will have to be that very neutral way of presenting the evidence and the law, and not actually instructing the jury to bring a particular preferred verdict. In any case, as a lawyer, and that's one thing I should have also touched on earlier on, a lawyer, you have to take notes, listen well in the courtroom and take notes. And after every proceeding, and that's one thing I learned when I was in master, after every court, you have to send a letter to the court registry and request proceedings for the day. Get the proceedings, review the proceedings, and make sure that the proceedings that you have accurately reflect what transpired in the courtroom, so that if there is any discrepancy at the next agenda date, at the earliest opportunity, you have to bring it to the attention of the court so that there will be the necessary reconciliation and rectification to ensure that there is accuracy in the record of the court. Mind you, you have to look at the Courts Act. Look at section 69, section 70, and 68 when it comes to minutes or the record of proceedings. And that is the official record of the court. And that is why, as a lawyer, you should be interested in what the court is keeping as a record. Thankfully, now we have this DTS, this digital transcription system, where most of the courts where these services have been deployed, you have the screen or monitors there. So as the recorders are making the typing, the lawyers can look at the screen. But my observation, sitting as an additional high court judge in some of the trials, is that a good number of lawyers, they don't bother to look at the monitor or the screen. The monitor or the screen is there not just for cosmetic purpose. It's there for transparency, for you to know that this is what is being captured by the court as a record of what is happening. So look at it. If there is an error, you draw the judge's attention to it, then the necessary adjustment to be made, you move on. Yes. Thank you.
Thank you, my lord. Now we have Eric Isel. Eric, kindly ask your question. You can unmute.
Hello, please, can you hear me?
Yes.
Yeah, thanks for the opportunity, my lord. This is a follow-up to John's question. So you talk about preparation. So you have a lawyer that is well prepared for a case, but a lawyer stands before the judge and the judge is not letting the lawyer do the case. So how do you go about it? Because in some cases, it's very frustrating that the judge is not even allowing you to talk and also explain your case. So how do you go about it? Thank you.
Right. Thank you, Eric. Yes. Judges who prevent lawyers from presenting their case and they will rather be pontificating, that is not good enough. But again, it will depend upon the specifics. So we cannot generalize. It will depend upon the particular configuration of facts or scenario before we can actually understand what is happening. But for example, is it about motion? If it's about motion, for example, we know Supreme Court authorities, senior lawyers and so on, which among other things says that a court determines how to manage or determine or conduct the motion. So for example, if motions, you have filed a motion and the return date, the court is satisfied that everybody is safe, the parties are there. Some judges, if, for example, the motion is not contentious, or even if it is, but if the judge has a basis to grant or refuse it, and he or she can make up his mind, technically speaking, it's not mandatory that the judge should allow you to make some lengthy submission. After just announcing yourself and you saying that you have this motion, the judge can say sit down. And then the other opponents will also say they will oppose. The judge can just sit down. What is important is that can the judge give reasons for refusing or granting the application? But in terms of style, we don't have any prescription, any dogmatic formula as to this is how it should be. Yeah, so that one is there. Now, when it comes to cross-examination, and if you look at section 69 of the Evidence Act, if I'm not mistaken, which talks about the fact that the court is supposed to control the mode of interrogation to ensure that things are done rapidly and then the witness is not embarrassed and so on. If it's cross-examination, yes, the judge has the power under section 16 of the Evidence Act to ensure that questions which are asked are relevant, are rapid, and they are not just meant to embarrass or harass the witness. So that can be done. But beyond that, the judge will have to restrain himself. And even that role becomes probably more significant, where maybe there's no legal representation for the other side.
Thank you. We have another question from it's a number 4982. Kindly introduce yourself and
Hello.
hi. Kindly mention your name and ask your question.
Hello. Good afternoon, my lord.
Afternoon.
Good afternoon.
Yes.
Please, I want to know in which way can a court disrespect a lawyer fact or argument presented in the court?
In which, let me understand your question. In which way can a court disrespect
Yeah,
a lawyer's
a fact in the courtroom?
Lawyer's
fact
fact
in the courtroom. In the courtroom.
Okay. All right. Good. Now, where a lawyer has presented a position, of course, it will depend. If it's just if it's not like a motion, or if not like you conducting cross-examination, maybe sometimes just a case management or ongoing no directions, and lawyer, for example, has said something, and then the court disagree. Before the court to disagree, the court will have normally push the lawyer to provide the basis or maybe a particular information that he or she is saying, which the court also armed with some other information seems to disbelieve what the lawyer is saying. I think that will be the case in majority of cases, unless maybe in an exceptional situation where maybe a judge is becoming very emotional, which should not be like the case. Yeah.
Okay. Thank you, my lord.
Very well.
Thank you, my lord. Please, to come out again, I am ready to buy LLB forms. I shouldn't have joined you, but precisely I need a little counseling. If I may get your number.
Oh, you can leave your number in the comment section. I'll contact you after, and we will
Okay.
take that.
Okay. Okay. Because I have developed more spirit in studying the law.
Okay. Thank you very much.
Okay.
Okay. So my lord, there's a question from Frederick. He's
Yes.
asking what advice you would give to junior lawyers who appear before superior courts, like the Court of Appeal and the Supreme Court, especially when they are being bullied.
Okay, good. To start with, I would like us to correct the word bully. The Court of Appeal or the Supreme Court, in my view, will not bully any lawyer. Yes. So we don't bully. The courtroom is for everyone. No, what happens is that I know we have in mind, again, it's a preparation. If you prepare well and you know what you are going to do, everything is on point. Nobody would even become interested in how old are you at the bar. Now, how old are you at the bar becomes important when you start making certain unpardonable elementary mistakes. Then we become interested. Even at a trial court, we become interested. Have you finished your pupillage? Have you done this and so on? But then if you are prepared well and you are doing what is expected of you very well, that may not become important. Should it even happen that some of our senior judges, because of a certain traditional thinking, would like to say that you must be of a certain minimum number of years at the bar before you come to the Supreme Court or the Court of Appeal. You shouldn't even be worried. There's a way of going about it. I remember many years ago, as a young lawyer, you go to the Court of Appeal, and let's say you are just 2 years or so at the bar. You go, you see a senior. When you announce yourself, you can say that I'm being led by Mr. So and so. I'm being led by Mr. Kwame Boafo. You have talked to him, the senior. Please, I would like you to lead me. The person will say, no problem. So, when you say that I'm being led by, now, even if you are just a 1 year at the bar, once you say you are being led by, you can go ahead and then be a representation, assuming that is something of even important to some judges. you have actually navigated that particular aspect.
Thank you, my lord. We have another question from Richard. He's saying that you mentioned about discretion, and when judges speak of doing substantive justice rather than technical justice, where should the line be drawn so that judicial discretion does not undermine legal certainty?
Please repeat that again. I was looking at, I've seen a couple of things in the chat. My mind
Yes,
went
he's
there.
asking, when judges speak of substantive justice rather than technical justice, where should the line be drawn so that judicial discretion does not undermine legal certainty?
All right, thank you. Yeah, so we are, for example, talking about the old battle between form and substance. And of course, we know under 81 of CI 47 framework, and this improvement over under 70 of the the repealed LN 140A regarding, for example, failure to do certain things under the rules. Previously, as we noted, the court had the discretion to make a determination as whether, if, for example, someone is supposed to file his statement of defense within 14 days after entering appearance. The person filed it 16 days, and the other party comes to court to say that, no, you're out of time. Yes, he's out of time, but the question is, does it go to the root of the matter? Does it affect the jurisdiction? Does it affect anybody's capacity, and so on? So the court, for example, pardon it, and if the other party took it up, probably costs will be awarded in favor of the person. And the court will say that we are allowing substantial justice to prevail over technical justice. So, but the point we should note is that depending upon the level of the court, okay, when it comes to Supreme Court, for example, Supreme Court is a policy court, and I think there's a noise from the background.
Yeah, he's been muted, my lord. Sorry about that.
So Supreme Court, for example, is the apex court, okay, of our republic. And because it's the apex court, the Supreme Court has a lot of latitude, flexibility when it comes to cases. For example, a case that, ordinarily speaking, the outcome should be in a certain way, the court has the power to look at the unique dimension of that case and say that, yes, despite the fact that this is the established position, due to the justice of the case, and only for this particular thing, we think that as the apex court of the court, where a country has signed up for rule of law, freedom of justice, and so on, and then the court will come out with some solution. And that solution will be based upon the substantial or the substantive justice as opposed to the technical justice. So that one is there. But then when it comes to court of appeal, for example, an appellate court has a very strict jurisdiction, and where a trial court, for example, has exercised discretion, an appellate court cannot just interfere with it unless the trial court actually took into account matters which ordinarily should not be taken into account, or it exercised the discretion in a way which any court informing itself of the requisite law and the facts on hand would not have come to such a conclusion before it would interfere. Otherwise, it's very limited. And that is why we often say that appeal is a creature of what? Of statute. And that is why, for example, when it comes to filing of the written submission, you have 21 days at the Court of Appeal. If you exceed even by 1 day, you are still out of time. The court cannot ignore it because the law is very strict in that regard. Then when you come to the High Court, as I have already mentioned, Order 81 and so on, when it comes to matters which do not actually go to jurisdiction or certain statutory precondition as to how certain type of actions or certain proceedings should be done, where it's not about that, but then it's just about maybe some of the rules of court which have not been complied with. They should ordinarily not stand in the way of the progress of the case and the justice. And that will be another example of saying that we will allow substantial justice to prevail over barring technicalities.
Thank you, my lord. This is from Priscilla. She's asking what your opinion is on a district magistrate telling an unrepresented client to shut up in open court when the client was attempting to give further explanation on her exhibits.
If that happened, that is very unfortunate. And then it's very unfortunate. So just as lawyers, we do continue legal education for you. Judges also have what they call the JTI, Judicial Training Institute, and from time to time, workshops and seminars are also organized. So the district court is a court of summary jurisdiction, and is what we call like the petty claim court, as it were. And it is expected that greater majority of the users of that court will have no legal representation. And for that matter, if that happened, then that is really an isolated case, and that is not the true position of what should be the case at the district court. Yes.
Thank you, my lord. This is from Miss Musei. I'm going to read everything. Respectfully, my lord, you are inarguably one of the best lawyers around and now a judge shining at the bench. My lord, I've noted your comments this afternoon on how to achieve the best courtroom practices. However, I would like to ask, what would be your candid breakdown of the strategies and resources you would recommend to a new lawyer to ensure that such a lawyer is well-versed in courtroom practices and on top of the practice in law in general? Thank you.
Right. Thank you very much. Thank you for your compliments. I don't think I'm worthy of all those kind words. Yeah, so strategies for a young and a new lawyer to actually excel. So first of all, we have to remember that a lawyer who is effective in court is a lawyer who advances the client's case. Mind you, you have a client, and there are many lawyers and your client came for you. So your client does not just got the extra money to waste. He wants somebody who can effectively represent him or her. And then an effective lawyer must assist the court. The court is there to do what? The court is there to adjudicate. To adjudicate means that to find out the relevant law, establish the right facts, apply the law to the facts, and come to some conclusion, regardless of who is winning and who is losing. So your duty as an effective lawyer is to help the court in that respect. And then you must understand procedure. And that is why I advise that as a lawyer, your rules book, your CI 59, which is a district court and rules, your CI 47, High Court and Circuit Court rules, CI 19, Court of Appeal rules, CI 16, Supreme Court rules, the Court Act at 459 as amended, and of course, the Constitution itself, and then the Evidence Act. And then if you do some criminal law practice, your criminal procedure code. These are procedural rules you should read every day. You should read every day so that your procedure is sharp. If your procedure is sharp, you have won half of the battle already. And if a lawyer, for example, comes to court the first time, I notice something. Does the lawyer know the file? Lawyers, they get up and right away, sitting over there, you the judge, you can tell that this lawyer is not familiar with the file. And some of us who have been practitioners of those teachers before, we have a very interesting way of trying to test some of these tricks. We can, I can just ask something from the docket just to test, how ready and how conversant the lawyer is with the file. And again, can a lawyer identify the rare issues in controversy? That is very important. That is very important. And how you address, the courts is also very important. So in terms of strategy, I would say that read your rules of procedure every day. Now, with respect to pleadings, please don't joke with pleadings. All the time you're doing a case, all the time go back to the pleadings and be reading them, so that if it is necessary to even amend your pleadings, be able to amend the pleadings at the earlier stage. Sometimes some lawyers will even not pay attention to that. It is when they are writing the address, when they've gone to read the whole of the trial transcript, then they realize that, oh, if this is what has come out, then we should have amended this aspect of our pleading. But then that may be too late. But if you've actually been paying attention, you could have done the amendment at the earliest opportunity. And then if you are going to court to move motion, I think somebody requested that I should share some thoughts on how to move a motion or how to respond to a motion. Okay, so when you are a lawyer and you are going to court, let's say the business for the day is a motion. You are for the applicant or you are the respondent, you're opposing the motion. Before you go to the court, every motion is going to be based upon a particular rule or set of rules, or worst case scenario, inherent jurisdiction of the court. Read the motion paper and ask yourself, what rule entitles me to the relief or the prayer I'm asking for? And then ask yourself, are there decided cases which have pronounced upon this particular rule? And if there are, which of those cases, for example, assist the way a manner I want to use this rule to convince the court to grant me the relief that I'm looking for? You have to do that preparation. Now, when you go to the courtroom, of course, the reverse is also true for the one opposing the motion. You have to do the reverse of what I've said. Now, on the day when you go to the courtroom and the court say that move the motion, know that the judge has got a lot of cases before him or her, okay? So be concise and straightforward to the point. After saying that, before my lord is the motion or notice for so and so, go straight and say that, my lord, the rule or the law is that to get this and this and this thing, and then in terms of paragraph this, in terms of paragraph that, the applicant has satisfied these requirements. Then look at your opponent's affidavit in opposition. If there is something significant in the affidavit in opposition which controvert the position in your affidavit in support, then you address that. And again, if there is an authority, okay, if there is a case from your preparation which you got to know that it assists your opponent who is opposing the motion, don't be silent about it. Talk about it and say that, Lord, a very important case as far as the instant application is concerned is the decision of the Supreme Court, the decision of the Court of Appeal, whatever in this. Then you go ahead and say that, my Lord, if you look at the instant case, it's not certainly on all fours with that particular case. Then you point out the distinguishing factor. So before your opponent even comes to address that point, you have prepared the judge's mind to be extremely cautious in listening to what the opponent is going to say with respect to that particular authority. But then if you are silent and you have to sit down for your opponent to come and speak about that authority which does not assist your case, and then later on you get up and say that, my Lord, I want to reply on point of law. Yes, I mean, the shine will have already gone. And the first impression, it will be difficult for you to raise it. But if you had anticipated it, what it means is that you are very much aware of that authority and you know that it's relevant, but then it doesn't really meet all the requirements or circumstances of the case before the court. So those are some of the things. And then with respect to cross-examination, let me say something. If you are going to be a good trial lawyer, cross-examination is very important. And cross-examination is using your understanding, bringing your understanding to bear on the case. And that is why you have to understand the pleadings well. And then pay attention to details, pay attention to matters which are really germane. And then ask the right questions. Put your thought down before you go to the courtroom. Put your thought down. Don't take it for granted that, oh, no, when I go to courtroom, no. Put your thought down. Sit down and plan your cross-examination. And then if you plan your cross-examination well, whatever question you are going to ask, you know the answer to anticipate. So whatever answer is going to come is not so much of a surprise to you because you've prepared the question. You've anticipated it. And because you've anticipated it, you know another question, which is going to, for example, help you to mitigate the effect of that particular answer, which the person has given to the other question that you asked. But it all comes from preparation.
My Lord, following up on cross-examination, Ebenezer is asking some techniques in raising questions for cross-examination and also how to conduct CMC.
Okay, so let's start from the CMC. CMC is a recent thing. When I was a law student learning civil procedure in 2001, we didn't even have a CI 47. We learned on the LN 148 then. Just in 2004, then the CI 47 was adopted. And not too long ago, we also had the CI 87, which has introduced what we call the witness statements, and which is very good. So right now, what is happening is that at the application for direction stage, when the courts and the lawyers will work together to try and identify the most important issue, which will eventually be set down for trial, the court will also give directions, including the filing of witness statements. So the evidence which your witnesses will have entered the box to go and give a long narration of the evidence in chief, that will be taken care of by the witness statement. And all the exhibits which we intend to rely on will also be attached to the witness statement. Now, the CMC is a stock-taking exercise. Under CR 87, the parties are supposed to file to go like a pre-trial checklist. A pre-trial checklist is supposed to take account of, in terms of pre-trial protocols, is there any outstanding thing which has to be done? For example, were interrogatories done? Have interrogatories been served or requested and not comply with? Is there any outstanding discoveries? Or did anybody request to further better particular which has not been done? Has the court, would it be necessary for the court to appoint any expert witness? How many witnesses are you bringing? Would they require a particular language interpreter? And so on and so forth. So all these things are actually indicated on the pre-trial checklist. And then on the day of the CMC, the rare purpose of the CMC, as the name suggests, case management conference, is to do the final preparation to start the trial. So you come, the judge will have to start from the plaintiff. The judge will work with you through your pre-trial checklist. And then we also physically go through the witness statements you have actually filed and make sure that everything is in order. The exhibits which have been attached to the witness statements will have to be labeled properly. So the plaintiff will usually use the alphabets. Maybe exhibit A, exhibit B, C, and so on. Then you continue for all the witnesses being called by the plaintiff. Now, the defendant will use the numbers 1, 2, 3. So the court will make sure that all these are labeled properly. A lot of lawyers make a mistake when it comes to labeling of exhibit for trial. The labeling of exhibit for affidavit is different from trial. Affidavit will often use the initial of maybe the deponent. For example, Ernest Owusu-Dapaa EOD, EOD 1, EOD 2, EOD 3, or something like that. So that is fine for affidavit exhibits. But then when it comes to trial exhibits, the conventional thing is to do the exhibit A, B, C for plaintiff, and then exhibit 1, 2, 3 for defendant. So the judge will make sure that all these things are done. And the judge will also try to estimate. So how many days? There's something we call the, CPC, case completion plan, which will be done as part of the CMC. So you need to do time budgets for the case. So plaintiff, you've seen let's say the defendant, you've seen the plaintiff witness statements, okay? So from your estimate, how much time do you need to cross-examine plaintiff? How much time do you need to cross-examine PW1, PW2, and so on? And then when that is done, the court will also find out, plaintiff, you've seen the witness statement of the defendant. How much time do you need to cross-examine the defendant? How much time do you need to cross-examine defendant witnesses? So all those things will be noted to enable the court to plan its diary and to actually give you a slot in its trial calendar. So that is the point about the CMC. And then is there something else? I think she also mentioned the cross-examination.
Yes, techniques for cross-examination.
Good. So cross-examination, what we should always remember is that you must have an objective. You must have a goal. What do you want to achieve? You are not just asking a question for asking sake. It's not because that the judge said that, oh, you should ask a question, or you should cross-examine, and then you just jump on your feet and start doing it. No, that is not it. You must have an objective. Your case, there's what we call the theory of your case. The theory of your case. In other words, based upon the understanding of the law, the cause of action or defense or whatever, what are the important elements which need to be satisfied before, for example, if you are the plaintiff, you'll be said to have discharged your burden of proof, burden of persuasion, and so on. So when you are doing the cross-examination, where you know the pleadings, and that is why I said that the pleading is important. Know the pleadings. Sometimes you may want to use cross-examination even to push your opponent to depart from the opponent's pleadings. And if you depart from your pleadings, that has also got its own consequences when it comes of the case, isn't it? So know your evidence which has come up from previous trial. You are aiming at contradiction, maybe getting your opponent witnesses to be contradicting themselves. You need to be conversant with what has already gone on the record of the trial before you can achieve those things. And as I said, you must plan the cross-examination before you go. What you want to achieve, the things are many to depend upon the particular case. Either you want to expose the witness as lacking credit, that the court should not believe the witness, or it's not just the witness who should not be believed, but the witness story should not be believed. Two things. You may not be able to attack the credibility of the witness per se, but you may be able to attach the believability of the testimony. The testimony is one, and then the person carrying the testimony is another. It may well be that the person carrying the testimony is not truthful. So if the person carrying the testimony is not truthful, what you call the poison tree analogy, then the testimony is also likely to be infected, as it were. And then if you also have serious contradictions or inconsistency in the testimony, then the question is, unless there can be really, really proper explanation, otherwise, the bearer of that testimony will also be untruthful. So it all depends upon the particular type of case. But one thing we should know now is that when you're doing something, for example, everybody do a land case. When you're doing a land case, you must always be interested in the identity of the land, okay? And you have to make sure, and of course now we have the Land Act, for example, even insists that composite plans should always be what should be made. And whether the judge has ordered it or not, as part of you being on top of your brief, at the direction stage and so on, you have to prompt the court to order that the composite plan should be made, because that is important. There should be clarity as to the identity of the land the parties are fighting over. And when you're also doing your cross-examination, all those things are important depending upon the particular witness who is being examined. But the bottom line is that prepare. Also, avoid open-ended question, the basics we learn in your law of evidence, and use closed-ended question. Open-ended question are questions which enable the person being cross-examined to go to town and talk at length. If you are asking open-ended question, don't expect the judge to stop the witness. The judge did not ask the question, you ask the question. So a good cross-examiner you will be very sparing in asking open-ended question. You rather target close-ended question which require yes or no, and so on. Okay.
Thank you, my Lord. We are a bit pressed for time and still have several questions. So we may not be able to go through all of them. But now I'll give the floor to Richard to ask his question. His hands has been raised for some time. So Richard, please ask your question.
No, I don't have any questions. Sorry. Thank you.
Oh, okay, Efri.
I think somebody is saying that if you have an objection on admissibility of exhibits attached to witness statements, example, no stamp duty on indentures attached, at what point do you raise it? CMC or after the witness statement has been adopted by the court? Okay, good. So cases like the ex parte before and so on, and then Lezoris. Right now, in terms of objection to tendering of a document, you do it when the evidence has been offered. As we know, at this section 6, section 6 of the Evidence Act, yes. That is where you make your objection. At the CMC, evidence has not been offered. The CMC just a stock taking. Okay, in the past, and of course, if you look at the rules of court, their thinking probably will have been that objection to exhibits and objection to the paragraph of the witness statement could be done at the CMC stage. And we all used to do that until the Supreme Court came in later on. I think that the four in the other line of cases to say that though you actually raise objection when the evidence has been offered. So the crucial question is, at what stage is the evidence offered? The evidence is offered during the trial, not at the case management conference. And for that matter, objection to whether a document has not been stamped or that something is not admissible, it will be done during the trial, not at the CMC stage. Now, the amendment to how they made to the Evidence Act, if the CMC is to be used in order to minimize, objections during trial, then they'll have the amendment to the Evidence Act, but not until the Evidence Act has been amended. The rules of court, which the delegated legislation cannot really amend, appearing legislation like the Evidence Act.
Thank you, my Lord. There is an interesting one from Christian. He's asking what a lawyer should do when a magistrate told the plaintiff to go to Nogopo to go and look for her money when the defendant has not yet responded to the plaintiff's statement of claim and her lawyer was not in court on the said day.
Yeah, as I said, those things, I'm sure.
And yes,
Either the judge is just cracking a joke or something. It's not really what the
yes,
law
he's
is
also
asking do.
very well, my Lord. He's also asking whether there's a recommended book on detailed or step-by-step approach of courtroom practices.
Oh, all the things that you learned in the school are important, but in terms of courtroom practices, the best guide is watch, watch, watch. That is, watch the bench, watch other lawyers. As we go to court, we learn from each other. Lawyers, judges, we learn from each other. You observe lawyers conducting their cases. And that is why it is wrong for lawyers to rush to leave the courtroom. When I was in practice, there are days I don't have any case or I finish the case. I just be sitting in the court just to watch or observe other lawyers conducting, cases, moving motions or conducting cross-examination, or as it were. Even like the court of appeal, for example, you can go and sit down just to observe, because part of our training is by observation. You learn by observing others. So as you observe others, you see the good examples and then the bad examples. Obviously, something is bad. You yourself, as you are watching and observing, you say that no, this one there is no good, so I won't learn that one. If something is good, you see it, and then you add it to your repertoire of experience and skill sets. Yes.
My Lord, thank you so much. It's been insightful. We are grateful for your time, and we hope that you join us for our next session. Thank you so much, and thank you, participants. We had over 263 participants. We are grateful for your time, and thank you all. Unfortunately, we cannot take any more questions. We've exceeded our 1 hour, 30 minutes. It's almost 4. My Lord has other engagements, so please look out for Legal Mentorship Network series. We will be coming your way with series of these webinars, so look out for it. Thank you all. Thank you, my Lord. We are grateful.
Right, thank you.
Bye.